This is Herman Thorson from the Thorson Law Offices, and the third of our video YouTube instructions to brokers and lenders in the mortgage industry. Today we're going to cover defense, and that is defense when investors or lenders ask mortgage brokers to buy back loans or pay for losses on loans, and what you can do about it. There are two, now one, lender back that we believe for some reason their contract is incorrect at best, and a pending lawsuit over it. In particular, Flagstar Bank has sued in its Michigan court because those of you that have agreements with Flagstar Bank know that their lawsuits are set up for Troy, Michigan as the venue. And they will sue when a lender suffers a loss, such as Flagstar if they have to save the loan and portfolio it, or when they have to buy it back from Fannie or Freddie. And they look to you, the mortgage broker, to make them whole by paying for the loss that they have to pay, or buy the mortgage back, or take it back and sell it on the what is referred to as the scratch and dent market. The lawsuit I am talking about is being handled by a very competent attorney representing the defendant, and I'm sure Flagstar has competent attorneys there, in the United States District Court, the Eastern District of Michigan. If you want to follow the case along, the case number is 2:13-CV-13973, and it is still ongoing. What's interesting about it is that there are multiple, or at least two defenses to this lawsuit, one of which is being used very competently by the defense attorney. And that is, Flagstar is suing because the loan or loans involved are not up to par and do not comply with all laws and regulations as set forth in the contractual agreement. The lawsuit was filed in September of 2013 and is still ongoing today. Flagstar had brought a motion for summary judgment just based on the contract and stating that we have a contract, the loan's bad, we should win. That motion by Flagstar was denied, and the motion was denied on April 30th of this year. What's equally interesting is the defendants have now filed a motion for summary judgment, and the basis of their defense is that some of the errors in the loan files were not created by the brokers. They were created by Flagstar employees or those acting on behalf of Flagstar, because the errors were created after the loan was brokered to Flagstar Mortgage. And that is the defense primarily in this particular case. There is a second defense in Flagstar and several other lender cases. One of these is you have to read the contract that you signed as a broker with any lender. In some of the contracts, the lender is saying they are purchasing the loan from the broker. The broker never funded the loan unless you are in one of the states that allow table funding, or you have a warehouse line of credit and in fact funded the loan. As a broker, you are submitting the loan for funding to the lender. Therefore, when a contract says the loan is being purchased from you, and you are in fact not selling them the loan but merely submitting it on documents, it's arguable the agreement is not valid because the lender is not purchasing the loan. As such, they are relegated to the rules of common law or the laws of the state pursuant to the contract. IndyMac, for those of you that have been around long enough, had the same type of contract, and we've used it with them when they were around as a pretty valid argument when we were defending our clients. To the point, if memory serves me right, none of our clients were actually sued. In this particular case, we are defending several cases, none of which are in litigation, at least at this point, and we've been doing that rather successfully when brokers are pursued for buybacks. The other, and there happens to be a third defense, is most of you are corporations. These agreements are signed by the corporations, and so the corporation is the one getting sued, not the individual. As a broker, you can surmise what your defenses would be in this particular case in the event you are sued. Most of the time, we have been able to settle our cases either for no payments because our clients did nothing wrong pursuant to any contract, or with minimal types of payments, as the case may be. That doesn't mean your case will settle minimally, because each case bears on its own facts, just like the Flagstar one I was telling you about a moment ago, which is entitled Flagstar versus Estrella et al. And Mr. Matthew Heron is an excellent attorney that I am in contact with on the case, keeping track of it. I have pulled the docket today, which is May 30th, and at the moment, the hearing set for the defendant's summary judgment motion against Flagstar is set for July 23, and we will continue to follow the case to see what happens with it. Thank you for watching. If you are interested and you find these videos informative, then please hit the subscribe button below. If you would like to know more about our firm, then you can click below as well. In addition, we have an excellent personal injury attorney, and if you have been injured in some form, then by all means please contact us, because all consultations on personal injury are free, and in fact we don't get paid unless we collect. I wish you the best of luck in your business, and may your endeavors be successful. Thank you for watching, and we will see you next time.